Now we are living in a globalized environment. If you are the best expert of your field in your country and you not understand anything about what happens elsewhere, you will continue to be the best expert in your country, but you will not count so much in other environments.
I would be interested in which typology of investment or construction projects are currently known in Italy regarding the public structure, infrastructure, or civil projects.
After the COVID-19 pandemic, we experienced the opportunity to get a lot of financing from the European Commission in terms of a plan of resilience. And thanks to that plan, now we are having a very good moment in terms of new works in Italy from a public standpoint. So railways, bridge, and also roads that are financed by such plan. This is really important to consider that also such funds are also used to build up a new hospital.
Under the Italian law, which types of contracts for construction is used in these projects?
Honestly speaking, in Italy we do not have a large experience in terms of standard contracts. I'm trying in my position as Secretary General of the Italian Society of Construction Law and now as Chairman of the European Society of Construction Law to introduce such standard terms in Italy. Like FIDIC, like JCT, we have several standard terms at an international level, and we are all persuaded of the fact that such standard terms are really important and really useful in the execution of any kind of works.
Hello everyone, welcome to Business Law Talks, a new edition of our podcast. We are honored to welcome today Mr. Roberto Panetta, founder of Panetta Law Firm, specialized in business law, construction law, arbitration, mediation, and dispute board. He's the chairman of the European Society of Construction Law, Secretary General of the Italian Society of Construction Law, professor of private law at Bocconi University in Milan, and professor of business law at LawASE of Rome University, and also he's a visiting professor at the Bucharest University of Economic Studies. Hello, Roberto, and welcome to our Business Law Talks podcast.
Hello, good morning. Thank you for this opportunity. I'm happy to be here. This is my fifth year in Bucharest as a visiting professor of your university, and I'm happy to share this moment with you and to provide as much as I can my experience and my point of view from an international standpoint and also from an Italian standpoint.
Well, our subject of this session of the Business Law Talks will have a subject things related to the construction law, being both system of law based on civil law, the Romanian and Italian system of law share some present similarities in regard of organization of the system of law, but also there are certain specifics to each country which are very interesting to emphasize in our discussion of today. Thank you for accepting our invitation, and at the beginning of our discussion I would be interested in which typology of investment or construction projects are currently known in Italy regarding the public structure, infrastructure, or civil projects. Could you mention some of them?
Yeah, for sure. We have to divide into two categories. The first one is works financed by public authorities, and in particular financed by the European authorities. After the COVID-19 pandemic, we experienced the opportunity to get a lot of financing from the European Commission in terms of a plan of resilience. And thanks to that plan, now we are having a very good moment in terms of new works in Italy from a public standpoint. So railways, bridge, and also roads that are financed by such plan. This is really important to consider that also such funds are also used to build up a new hospital. And this means that all such works are addressed to provide to citizens a better future. So such funds are provided by the European Commission, are used by the Italian authorities. They are specifically oriented to achieve a specific purpose that are provided when such funds have been provided. So we have this kind of experience from a public standpoint. For what concern private contracts as well, such works for sure are not financed by the public authority. Instead, they are financed by banks, by some private subjects, and for sure this kind of works are addressed to satisfy some private economic interest. But in any case, also thanks to such private works, we have, for instance, in some cities like Milan, but also Rome, we have a lot of works that even if they are specifically addressed to satisfy a private interest, at the same time they are enriching the entire city, because we must be sure we must be aware of the fact that even a private work is able to provide new value to the entire city. If you look at a new building, a new palace, a new apartment, even such private works are able to provide a new value to the entire city. So if the division between public and private works is a right division in order to better understand to what extent such works are financed, on the other side, in my view, it is important also to consider that private works are able to provide value to the citizen, even if they are not specifically interested by such works. So, in my view, it is important to consider this moment that is based on some funds provided by the European Commission and funds provided by banks or by private subjects as a good moment for the entire city, for the system at all. In my view, this moment must be not only this must be considered also a starting point for the future, in order to continue on this path and to provide citizens with the opportunity to live and to enjoy new cities, even smart cities, and also in new cities in terms of new materials, new projects, and so on. And so forth. So this is a situation at the moment in Italy for what concerns new investment, private and public ones.
Such large projects and such complex projects needs a proper allocation of resources. In Romania, for instance, the resilience plan funded by EU allowed us to initiate many large projects, but also to involve many contractors, national but also international entities from Italian, from Spain, and also from Turkey. And under this perspective, we are curious in Italy which type of contractors are used to be involved in construction projects. Are mostly national contractors or international joint ventures?
Let me say that in my experience, not only in this period, but in my experience of last 10, 15 years, in Italy, mostly we have Italian contractors be in place. This happens on the basis of the fact that our contractors are really renowned, even abroad. We have very good contractors with a large experience, in particular in civil works. And on the other side, perhaps we also have experience in terms of collaboration between different enterprises. So we have some consortium, some joint ventures in Italy regarding complex works. In particular, when such works contemplate, for instance, plant, mechanical plant, electrical plant. So when you do not have only civil works, but even mechanical and electrical works, that in my view it is the most of the works. This opens the door to many international contractors. Such contractors are not called alone, but they are normally part of a consortium or a joint venture. Such joint ventures can be of two types. On one hand, you may have a contractual joint venture. So such companies only stipulate a contract in order to execute such works, without constituting a new entity. So they preserve their autonomy and they participate to the execution of the works without making any separation between their patrimonial autonomy and their participation to the works. So international or even foreign contractors normally participate to such works in a contractual joint venture. Sometimes they also prefer to have a new entity. So they constitute, together with the Italian contractors, they constitute all together a new entity, and such entity normally is called as the project that has to be carried out, and such entity guarantees the separation between the patrimony of the contractor and the project. So in the event of any kind of a breach of contract or in the event of any kind of supervening circumstances, the entire patrimony of the company is not impacted by that specific project. These are two different approaches. Both of them are largely adopted. It depends on the choice of the parties, and such parties are free to choose whatever they prefer, because under the Italian law, both solutions are legal and admissible.
Under the Italian law, which types of contracts for construction is used in these projects? Are there standard contracts, or there are only based on civil law rules or normal contracts of construction?
Honestly speaking, in Italy, we do not have a large experience in terms of standard contracts. I'm trying in my position as Secretary General of the Italian Society of Construction Law, and now as Chairman of the European Society of Construction Law, to introduce such standard terms in Italy. Like FIDIC, like JCT, we have several standard terms at an international level, and we are all persuaded of the fact that such standard terms are really important and really useful in the execution of any kind of works. We know that the FIDIC Rainbow guarantees a book for every kind of work. So it is really important, in my view, to provide also the Italian environment with the opportunity to enjoy with such standard terms. But at the moment, such standard terms are not used largely in Italy. Just a few practitioners have a familiarity with this kind of standard forms. Normally, such works that we have just mentioned are regulated by bespoke contracts. So parties are called to stipulate clause by clause the regulation of their relationship. This is good on one side, because at the end of the day, you have your contract. You do not have a standard contract, but you have your contract well stipulated in your interest, and such contract is specifically designed for your work and for your person. On the other side, this is in terms of transaction cost, it is really expensive. And on the other side, the use of a bespoke contract, in my view, does not open the door to foreign experience and to the experience of engineers, architects, part of, for instance, the FIDIC Federation, and so on and so forth. So the fact that we do not use standard forms close the door to the experience of other parties. And when you close the door with respect to the experience of the other people, you are closing the door to the innovation of your country. So I hope that in the next future we may have both kind of contracts be used in our environment, but at the moment, bespoke contracts for sure are largely adopted.
Are the applicable provisions to the construction field in Italy included only in civil code, or there are also other legislative provisions which regulate the construction domain in other separate laws?
No. So if we talk about the private contracts, civil law is for sure the main source of law. So if you look at the civil law, you have most of the regulations, most of the provisions that you need in order to regulate your contract. But in addition, even for private works, you may have further special laws that regulate other aspects. For instance, supply of materials. Supply of materials is specifically regulated by a specific law, and it is not deducted in the civil code. In the civil code, we only mention sale contract, but not supply of materials. And supply of material or sub-supply of materials is specifically regulated by a specific law. If we talk about the public contracts, on the other side, you have at the same time civil code, special laws, and public contract code. Because for public contracts, we have the Legislative Decree 36 of 2023, and this is a code for public works only. So at the same time, you have to make sure that your contract for public works is not in contrast not only with the civil code for what concerns the execution of the relationship between the two parties, but such relationship must be also in compliance with the public contracts code for what concerns, for instance, the procurement phase. The procurement phase is not regulated by the civil code, but is widely regulated by the public contracts code. So as a lawyer, as a jurist, you have to keep in mind these two main sources of law and several specific provisions regarding some specific aspects.
Moving on to another subject, in Romania, in public procurement contracts, we use until 2018 the FIDI contracts, including the clauses regarding the dispute adjudication boards, which were removed in 2018 once we adopted new standard national contracts. I know that quite recently in Italy was introduced the statutory adjudication. Could you please share with us your experience with the statutory dispute adjudication boards in Italy under the new provisions of law?
Yes, so the statutory adjudication in Italy, that is called Collegio Consultivo Tecnico, that is the Italian name of dispute board. The Collegio Consultivo Tecnico has been introduced by the law several times, starting from a law enacted in 2017, and then on 2020, and then again in 2023. So now we are talking about the final version of dispute board, or Collegio Consultivo Tecnico, enacted by the Code for Public Works enacted in 2023. This kind of dispute board, Collegio Consultivo Tecnico, is really important in our environment. This is mandatory for public works, for important public works, in the sense that if such works have a price higher than 5 million euro, such dispute board is mandatory. The parties are called to nominate a board composed of 3 members. One member is nominated by the employer, the other one is nominated by the contractor, and both members are called to nominate the chairperson of this board. This is the bottom-up procedure that we know even at an international level. This is not new. This is only the procedure to be followed in order to have your dispute board. Such board, as I said, is mandatory for this kind of works, and for works that have a national relevance. So when you talk about, for instance, archaeological works, we are talking about Italy. So in Italy, we have plenty of archaeological works to be executed in order to have our patrimony be well considered, even at an international level. This kind of works provide for a mandatory dispute board. Otherwise, other kind of works do not have such dispute board as mandatory, but it is up to the parties to decide to have or not this board. In my experience, the Italian dispute board plays an important role in the execution of the works, because the dispute board is called to intervene on site to supervise the execution of the works, to provide the parties with recommendations, so any formal assistance during the execution of the works, and in the event of a first disagreement between the two parties, the dispute board is provided with the power to make a decision, and such decision, in the event that the parties have accepted this point, such a decision may have the value of an arbitral award. So it is final and it is binding. And this is really, really important, because this has the purpose to avoid an ordinary proceedings before the court, or even to avoid any arbitral proceedings. Why we should avoid this kind of proceedings? In order not to waste time, in order to have an immediate decision that is able to provide the parties with the works be executed on time. In my view, the Collegio Consultivo Tecnico now needs to be understood by all practitioners, but for sure in the next future it will be one of the most important elements for public works, but also for private contracts.
Okay, regarding the settlement of disputes resulted from such public contracts, is it allowed in Italy to have arbitration designated at the court who has jurisdiction to settle such disputes?
Yes, arbitration is largely adopted in the construction contracts, in particular in private construction contracts. Normally, the arbitration agreement is in most of the construction contracts that I have seen in my experience. So normally, arbitration and constructions are studied together, are considered together. Normally, arbitration is provided when a construction contract is in place. This is what happens in the event of a private contract. For what concerns public contracts, thanks to the Legislative Decree 36 of 2023, so we are talking about a very recent law, arbitration is also admissible in public works. In the past, it was not possible to go before an arbitral tribunal for what concerns public contracts. Now it is possible, and the parties are free to choose, or in the procurement phase, or afterwards, even by stipulating an arbitration clause during the execution of the works. They are entitled to ask the arbitral tribunal to decide their dispute. But even in the event of public contracts, the consent of the parties is the cornerstone, in the sense that only with the authorization of the employer, the public employer, and of the contractor, arbitration can be put in place for what concerns public contracts. And as I said, the employer is required to provide the procurement to highlight during the procurement phase his will to have an arbitration in the event of any dispute, or in the event that the procurement phase is not initiated for a reason or for another, even in the invitation letter. In the invitation letter, such a choice of arbitration instead of a state court must be highlighted. And in this event, contractor is called to accept or not this choice made by the employer. And in the event that contractor accepts this kind of choice, the arbitral arbitral agreement is deemed to be concluded, and then any dispute will be resolved by the arbitral tribunal.
Thank you for very interesting insights regarding the construction law in Italy. Last but not least, as you are the chairman of the European Society of Construction Law, the organization which reunites the national European societies of construction law, I'd be interested in finding your opinion on the advantages of being a member of a national society of construction law, and also we would like to find more about the projects contemplated for the next year by the European Society of Construction Law.
In my view, the most important advantage to be part of a national society is to be part of a community. Being part of a community means to participate to Congress, webinars, conference during the year, not only to meet your old and new friends, but in particular to be adjourned, to be updated, to know and to listen about new developments of your field. Otherwise, if you are not part of this kind of community, you are completely isolated. You are not part of a community. You do not have the opportunity to talk with your colleagues and to understand which are the new horizons of construction law. But in my view, of every field in our profession. So I encourage all practitioners to participate to our conference, to our webinars, to be part of our community, not only to enrich our society, but in particular and mostly in order to enrich themselves. So this is what I consider it is the most important added value to be part of a community and to be part of a society. For what concerns the European society is an umbrella society. So, as you have just said, European society comprises about 21 states in Europe. And the European Society aims at organizing at least one conference per year, several webinars, and this is the opportunity not only to develop your national approach to your field, but also to understand what happens elsewhere in other countries and to appreciate the experience of the others. Now we are living in a globalized environment. If you are the best expert of your field in your country and you not understand anything about what happens elsewhere, you will continue to be the best expert in your country, but you will not count so much in other environments. So, in my view, it is important to develop both fields in order to be sure to be aligned with all the practitioners in your field.
And can you add something about the projects of European Society of Construction Law contemplated for next year?
Yes, for what concerns the European Society for the next year, actually we have several projects in place. For sure, the next conference that is the most important element of our activity will take place in Istanbul, and will be addressed on the uncertainties in construction. So now we have experience of many uncertain situations, uncertain circumstances in our sector, and this conference is specifically devoted to this subject. And apart from the conference, webinars on construction law, on arbitration, dispute board, for sure, and webinars addressed by speakers coming from all jurisdictions across Europe, but also from other jurisdictions, even out of Europe. We have also in mind to look at the ISCL book. The ISCL book is an initiative started in 2015. At that time, we prepared a well-organized book regarding all jurisdiction, all laws in Europe regarding construction law. And perhaps now, after 10 years, it's time to look again at that book and to start updating him in order to be sure that all laws are provided in that book.
Thank you very much for accepting our invitation. Thank you for watching us, and see you at the next edition of Business Law Talks. Goodbye.